My name is Eric Moschino. I'm from Plymouth, Massachusetts. I'm also here to offer testimony on H3541. It is difficult to argue against the assertion that the United States Supreme Court has become totally unmoored from its original purpose. Justices and federal judges are accorded undue reverence and significance. They increasingly encroach upon the lives of sovereign citizens, yet matters of commerce, liberty, and life and death were not to be in the hands of a few robed attorneys. How did this come to pass, and what can be done about it? Judicial independence is vital in a constitutional republic. This was recognized by those who foresaw the incremental expansion of judicial power. One of those was Brutus, writing in Anti-Federalist 13. Brutus, who was sought to be New York Judge Robert Yates, was particularly concerned about how the expansion of judicial power would impact the states. He wrote, quote, "Perhaps nothing could have been better conceived to facilitate the abolition of the state governments than the constitution of the judicial. They will be able to extend the limits of the government, of the general government gradually and by insensible degrees, and to accommodate themselves to the temper of the people. Their decisions on the meaning of the Constitution will commonly take place in cases which arise between individuals, with which the public will not be generally acquainted. One adjudication will form a precedent to the next, and this to a following one," end quote. As is evident, and as Chief Justice John Marshall's opinion in the infamous case Marbury v. Madison demonstrated, Yates was proven correct. Marbury confirmed the assertion made by Yates and expanded the authority of the court. As Marshall wrote in his opinion, the judicial power of the United States is extended to all cases arising under the Constitution. The expansion of power, unauthorized in the Constitution or by any subsequent amendment, resulted in disastrous interpretations and rulings. Consider the most obvious: then Justice Roger Taney's terrible decision and reasoning in the Dred Scott case of 1856. Taney and a few other justices ruled Scott, a slave, had no standing to sue for his freedom. This did much to bring about the Civil War. Ruling after ruling and edict after edict has followed. Again, folks, I thank you for your time. I urge you to vote favorably on H3541.